Buongiorno a tutti e benvenuti al webinar di oggi organizzato insieme agli esperti AON. In questa oretta e mezza parleremo di diritti di proprietà intellettuale, che cosa sono, qual è il loro valore per l'azienda e gli strumenti per tutelarlo. Lo faremo insieme a Claudio Perrella, socio consulente legale Anra e partner RP Legal, Vincenzo Aliotta, Specialist Director Financial Institutions AON, Fabrizio Iacobacci, socio fondatore e senior partner studio legale Iacobacci e Associati, Alexandra Towers, client manager EP Solutions AON ed Ellie Webb, intellectual property underwriter Tokyo Marine Kiel. Vi ricordo che il webinar sarà condotto in lingua inglese, ma per dubbi e domande, approfondimenti potete usare la chat come al solito. Non mi resta che augurarvi buon webinar e lasciare la parola all'avvocato Perrella. Thank you everybody and thank you to our faculties.
Buongiorno a tutti, esordisco anch'io con due parole in italiano, ma passerò rapidamente all'inglese. Good morning everybody. I'm glad I will introduce this seminar because the topic which has been submitted, it's very interesting. It's a hot topic and it's easy to imagine that it will be increasingly important. We have wonderful presentations. I received them and I went through them, and there is a lot of interesting material. I'm sure that we will be receiving a lot of inputs from the speakers. I guess we will have the time to address questions coming from the audience. Don't be hesitant, don't be shy. Submit anything you may wish to explore further, and I'm sure that the speakers will be happy to address your queries. We will start with a joint presentation given by Vincenzo Aliotta and Alexandra Tauer. I will have to summarize a lot their bios because they both have an impressive experience. Vincenzo has been in the insurance industry for more than 25 years. Graduated in economics with the first period of practice in London. He then moved to Italy. He has been leading the financial lines and mergers and acquisition practice at AON, and is now director for financial institutions and innovative lines, again with AON. Alexandra is client manager working for AON IP Solutions, specializing in intangible asset insurance, and is responsible for delivering innovative and effective IP solutions to a wide range of clients. Again, Alexandra has a wide experience. I've seen the material, and I'm sure that we will be receiving soon a lot of very interesting input from them. So Vincenzo, I believe you will be starting. So please, the floor is yours.
Thank you very much, Claudio, and good morning to everyone. I must admit I'm really excited and happy that we have the chance to talk about this new and interesting topic. Bear with me with just for a few seconds. I believe that you should start seeing my screen.
Exactly.
Okay, perfect. Okay, the screen is
perfect. Thank you.
Perfect. Excellent. Thank you very much. So what we are going to do today, we are trying to walk you through this, if you like, these new solutions that the insurance world is able to offer to face and to help clients to mitigate this risk associated, obviously, to the intellectual property rights and the use or misuse of those rights. I think that I thank again Claudio. This is us. This is myself and Alexandra. And I think that conscious of times, we can skip through this slide. And I'd like to spend a couple of minutes on the reasons behind, behind the investments that we did, and the reasons why we believe that it's quite important to talk about intellectual property. This is a slide that we have collated. We used and we started to look at the FTSE 500 index, and we looked at the value and the weight that the total assets of these companies have, and comparing the tangible assets versus the intangible assets. I think that this exercise could be duplicated, if we say in Italy, with the mid-30 or with any other, if you like, listing in any stock exchange. What it says is that the world is changing. The world has changed and continues to evolve. A few decades ago, we were only concentrating and mostly thinking about the tangible assets. The warehouses, the plants, the equipment, the machinery. And this is what we have always been used to look at. And from an insurance perspective, we became very, very good at measuring them and covering, because those were the assets that were most valuable for the enterprises, for the companies, and those were the assets that we could see and touch and feel. Well, the world has changed, it continues to change. And this slide shows that today, the real weight is in the intangible world. And intangible assets, for their own nature, are quite, as you may imagine, it's not difficult to, to imagine that. They are quite difficult to evaluate. You don't see them immediately. And most of all, at least from our perspective, they are quite difficult to insure. But the weight of the intangible assets compared to the tangible has grown immensely. Let's say that the value of a company these days mostly is represented by the data, the intellectual property, so to all this, if you like, intangible world. And within the intangible world, the intellectual property rights are a significant, a substantial portion of it. So this is the reason why we need to look at them. We need to understand how to measure them, how to weigh them, and most of all, how to provide solutions to our clients to be able to protect them. This is the reason why, moving to the next slide, in Aon, we really believed that that was the most important and significant thing to do. And we assembled at world level quite a vast team of experts coming from different fields, from different walk of lives. We are pretty much 130 professionals, across the globe, and with quite a big presence in EMEA, which is Europe, Middle East, and Africa as well. And as you can see, we thought that it was very important to bring people from a different walk of lives in order to be able to have a sort of a holistic approach, a 360-degree approach to the IP opportunity or IP risk. And this helped us to drive, if you like, the development in the insurance world. I'll touch briefly upon what, if you like, we in the insurance world mean when we talk about intellectual property. Now, intellectual property is quite a broad definition for us, and obviously we are making reference to the creation, if you like, of the mind, the inventions. It could be literally artistic works, any designs, any symbols, names or images that are used by our clients. There are clearly different types of intellectual property, and as you can see, we have the patents and obviously the trademarks that most of them, we are used to see on a daily basis. We have copyrights and also, if you like, the trade secrets. So these are the most important secrets of companies that obviously they use to be on the market, to produce their products, and obviously to be successful. And clearly the designs, what I thought is I used the Coca-Cola twice, but both on the trade secrets, the usual myth of the formula to make Coca-Cola, and obviously the design of the bottle, which is quite iconic and is recognized at world level. So let's say that when we talk about intellectual property, we talk about a broad array of assets, of intangible assets, which are definitely valuable to help a company and a business to stay on the market and to be successful. If I move to the next, if I move to the next slide, I'll say quick snapshot of what we have seen from our perspective in terms of risks, so in terms of litigations. Well, first of all, let me say that we have seen that the European Patent Office, the number of patents which have been granted have increased over the past 10 years. So the world is moving towards a direction where more and more patents have been filed and registered. And so companies are quite active in trying to protect, obviously, their intellectual property, what they believe to be their in terms of macro areas, we see that American and Japanese companies are quite active, definitely more active than the Europeans, but still, and within Europe, we see the German companies, which are more active compared to maybe some other countries. Clearly, there are some industries which are more, if you like, more prone, more IP-rich compared to other industries, and I refer to the digital communication, to the medical technology, and the computer technologies. But having said that, we can take any other industry, any other fields, and the companies within other industries, they will still have a basket, they will still have a suite of IP assets which are valuable for their business. What we have seen is that there is quite an increase in, if you like, litigation, and this covers both litigations within Europe or, let's say, within the United States of European companies. Clearly, that is quite important to bear in mind, especially for us, considering this audience, because most of you probably will also want to trade, to expand, and are already working over the Atlantic, over the pond. What we have seen is that when touching wood, touching metal, but in the unlikely event that one company is involved in an IP litigation, the costs to manage a litigation are quite substantial. Just the defense cost, and this is just probably an estimate, could be around a few million euros, and also the timing that takes a litigation to be completed is quite lengthy. Bear in mind that these data are skewed, are probably compressed towards the lower end, because most of the litigations they don't go to trial, but they are settled out of court. So it's quite difficult to capture the data regarding this litigation. So I think that the environment is quite complex. The cost of litigating an IP are on the increase. The frequency is increased. So it is a sort of a macro environment which we need to bear in mind. And this is the reason why it is absolutely important, absolutely vital that the insurance brings a solution and puts a solutions on the table for our clients. Just let me touch on this slide, then I will pass the floor to my colleague Alexandra, that can deep dive into what we see, into the solutions. Let's say that once a client is involved, there are various risks, so various areas that they could be touched. Clearly, our client trade secrets, as an example, the formula to make something could be stolen or could be misappropriated, and therefore, we have a need, because these clients are saying, I have a trade secrets, I believe that someone else is using it. What do I do? How can I prove it in court, or how can I try to cover the financial loss that I'm sustaining? How can I stop these other people doing it? Our client could, sometimes be sued for allegedly infringing a third party's intellectual property, and this is clearly, a defense matter and also a liability matter that needs to be addressed. In other cases, we can see customers that are sued because our clients' products, which maybe are part of a much bigger and more complex product that is put on the market, is allegedly infringing a third party's intellectual property rights. And again, this is just adding some complexity to the case that needs to be addressed. In other instances, we could see third party, on the other hand, infringing our client's intellectual property, and this is very much true especially for Italian companies, because we always say that we are quite bright, we are quite innovative. We are well known at world level for the design, for the iconic products that we can bring onto the marketplace. So it's quite common that other, if you like, countries are looking at us and they're trying to copy what we invent, what we create. So the reality is that we must be able to protect our rights also on international courts. Other areas, and you may think, some parties could try to invalidate our clients' intellectual property, trying to stop them to continue to use certain intangible assets, or asking to withdraw the products that have already been launched onto the marketplace. So, and again, this is another area where we need to address some solutions. So let's say that the world is quite complex. There are various scenarios, and claims are on the increase, both frequency and severity. IP is absolutely vital for the survival of our clients and of our companies. So this is the perfect recipe to say to the insurance world, well, you know what, we need to help our clients to work, to have a peace of mind. So with that, I would stop, I would pause, and I would leave the floor to my colleague Alexandra, that is very, very knowledgeable on giving you a sort of a broad view of what is happening onto the marketplace.
Thanks, Vincenzo. Would you be able to move on to the next slide? Perfect, thank you very much. So I'm going to look at a few aspects of specific risk that our clients are facing. The first one I wanted to touch on was non-practicing entity litigation. So non-practicing entities, otherwise known as NPEs or patent trolls, are companies that don't have any business function other than to acquire patents and insert them. So they generate all of their revenue from litigating against third parties. Patent trolls have been around for a while. They've been very active in the US, but we've actually seen very recently a huge increase in NPE litigation in Europe as well. I believe that for the last 5 years, NPE litigation in Europe has increased 19% year on year. So we're actually seeing a lot of our clients come to us that are very worried about this risk and defending against this risk. And NPEs are really out for a quick win. So they want to get this, off the table as quickly as possible. So they'll target companies where they think that they're not going to want to defend it too much. They just want to make the issue go away by paying away the claim. The areas where we're seeing the most NPE litigation is in the software industry. And this is because software coding is typically protected as copyright. However, you can get some software patents. And so if they are able to get hold of a software patent, it's pretty easy then to assert those against other software companies and claim infringement. So we're seeing quite a lot of litigation in the software industry from MPEs. And I would say the vast majority of clients that come to us with this issue are software companies. So that's also something to bear in mind. If you could move on to the next slide, please. So Vincenzo touched briefly on supply chain risk when he was speaking. This is again something which is a common conversation for us to have with our clients. So there's two ways to look at it. There's looking at it kind of in the supply chain going up. So a lot of companies today have to provide their customers with indemnities in the contracts that they have, where it says essentially our client will indemnify the customer for any litigation brought against the customer in relation to the client's intellectual property. And most contracts are containing these days, just because there's been quite a lot of high profile cases where customers have been sued for their suppliers' intellectual property. A key case study was earlier this year. Wells Fargo was sued for, I think it was about 300 million, because they were using a check deposit app software that was supplied to them by a company called Mytech. They didn't do anything in the production or the development of the app. They just used it, and it was supplied to them by Mytech. But they were actually had to pay out 300 million in claim for that because there was no clause within their contract that said that Mytech needed to indemnify them. So what we're actually seeing is smaller companies coming to us, well, not even just smaller companies, many different sizes of companies are coming to us where they're required to give an indemnity in their contract, but they maybe don't have the financial resources, or they don't have the financial resources to cover the exposure, especially when they're dealing with very big companies, because damages tend to be assessed on the revenues generated by the end product or the end user. And so in the example of Wells Fargo, they were sued for a much larger amount than if Mytech, who actually developed software, was sued directly. And so for these companies, having these contractual relationships with bigger companies just increases their exposure that much more. So we're seeing a lot of clients approach us for this. Then if you kind of think of it in the reverse of that, if you have a client who has a long supply chain behind them, for example, in the automotive industry where supply chains can really be huge, if there's not the contractual elements contained in each of the contracts, then essentially the client could be assuming a lot of liability for their whole supply chain. So what we have is a vendor risk management platform, which I think, Vincenzo, there's a slight overview of on the next slide if you want to move over. So the vendor risk management platform is something that we operate where we essentially will review all of the contracts that you have with your suppliers, and then we verify that all of your suppliers are both meeting and ensuring the contractual obligations. And in this way, it's just a measure that we're able to take to ensure that the exposure is essentially removed from both the client and from also the suppliers as well, because they don't have to worry about, you know, the increased exposure from dealing with larger companies. So this is a kind of a very brief overview of different industries and which ones, you know, we tend to see more risk in. It's by no means a kind of gospel slide. We deal with clients from various different sectors. However, this kind of gives a bit of an overview of which industries have a higher risk of IP infringement claims. I would say anyone kind of operating in the 1 to 3 bracket has a serious risk that they should be considering. The only thing that I would probably just point out is that for any companies that are working in the pharmaceutical sector, we have found it, and I'm sure Ellie might touch on this later on, this is just a trickier one for us to secure insurance for because there is so much litigation in the space. That being said, it's not impossible. It just might be a bit more expensive. So what is IP infringement insurance? So an IP insurance, like IP liability insurance policy, will cover a company for claims of infringement, and it will cover them for damages incurred, settlements, and also legal fees as well. There's various different elements that can be brought in to cover as well. So as I mentioned earlier, NPE litigation can be included. We work with a lot of insurers who will include that as standard. We also work with some that will only do NPE insurance for NPE litigation if this was a specific concern of yours. And then contractual indemnities. So this is where we were talking about your customers being sued because of your intellectual property. Another key thing is that it will cover for appeals and counterclaims as well. So if there was subsequent to you being sued for patent infringement or whatever, if you then want to pursue a counterclaim against them or appeal a decision or an outcome, the policy will cover for the legal fees incurred for that as well. Next slide, please. So there's the 3 kind of insuring clauses that we typically have on an IP liability policy. So the section A, which is infringement and misappropriation, this is for claims that are made against the policyholder for IP infringement. Then we have section B cover, which is indemnified party defence. This can be called different things between different insurers, but this is claims brought against your customers. And then section C is intellectual property rights protection. So Vincenzo mentioned that earlier. So this is essentially claims of where attempts to invalidate your IP are made. So that might be patent invalidation, trademark invalidation. So the section C cover will cover for the legal fees incurred in defending any attempts to invalidate your intellectual property. So there's kind of 3 additional elements to the cover that can be included. They're not necessarily always included as standard. So the business interruption and the withdrawal expenses I'll touch on first, because that kind of, I guess, ties in with the invalidation. So if as a result of invalidation you suffer any losses like loss of profits, or there's withdrawal costs, product recall costs, things like this, if there's any interruption to the business, then there can be an extension added to the policy that will cover you for that. That isn't something that is included as standard, but it's something that can be considered subject to underwriting. And then loss mitigation also, if there's any workaround costs, for example, if you do have a patent infringement lawsuit brought against you, the insurers can help you with workaround costs to try and mitigate the amount of infringement and to avoid as many costs as possible. So things like costs for things like that can be included as well. And these are just, I guess, again, other things that can be included within the policy. I think probably the one that I'll touch on, which is the most important out of these 3, is enforcement cover. Again, Vincenzo mentioned it earlier. This is something that, particularly for companies that are on the smaller end of the scale, so I would say for companies that have got revenues of under about 250 million, we're really seeing this as a key conversation starter. So this is essentially the reverse of IP liability. So it covers you for the legal fees incurred in pursuing litigation against third parties where you believe that they have infringed on your intellectual property. So I included this slide as just a bit of an overview, because one of the questions that we always get is, what cover do I currently have for IP related risks under my current insurance program? So we pulled this slide together that kind of gives you an overview of where you may have some cover and where you may not. I think probably the key takeaway is that there is some cover under other lines of insurance. So for example, general liability, E&O, cyber and media. There will be some, but it typically is limited, very limited, mostly in terms of content. In terms of patent infringement, there's no other policy that will provide full cover for that. So an IP liability policy is the, I guess, the best insurance solution to have in place to provide comprehensive cover for IP related risks. So where is the market at the moment? I would have a feeling that if you deal with any other lines of insurance, all you hear at the moment is how hard the market is. The one good thing is that in intellectual property, it is slightly better than the rest than other lines of insurance. So IP liability insurance has been around for quite some time, but in very recent years, we've seen more clients being interested in it, more companies are purchasing it because they're understanding the risk. And with that, we've seen an increase in data in terms of understanding claims and losses and things like that, which has meant that we've been able to better negotiate coverage, better increase capacity as newer insurers are getting more comfortable with the risk as they've been able to kind of see and understand the data. And retentions and pricing are actually either stable or decreasing, and Ellie might give a bit more of an overview from an insurer's point of view from that later on. But in general, it's quite a stable line of insurance, especially when you compare it to other insurances at the moment. And then finally, before I hand it back, this was just a bit of an overview of the application process. So from start to finish for securing IP liability insurance is about 5 weeks. We initially have if you were interested in securing IP cover, we would typically have a call with you, discuss the company, discuss the risk exposures, and then we would ask you to complete a proposal form. Once you've completed the proposal form, we will then send that on to insurers to review. They typically either come back with any further information requests that they have, or if they have everything that they need, then they're able to issue a non-binding indication. And then typically we'll normally set up a call to do with the client and the insurers to discuss. And then final bindable quotes are provided once the insurers have all the information that they need. And then once these terms have been provided, then the client will decide which option that they want to go with, and then we'll bind cover. So yeah, from start to finish, it's about 5 weeks. This can obviously take longer if there's more information that's requested going back and forth, but that's what we typically need. In terms of getting a non-binding indication, I guess the critical information that we would need is name, industry, the revenue. Obviously very important is litigation history. So if the company's been involved in any litigation, we would need to know about that. And then also an overview of the desired coverage. So is cover needed for contractual indemnities? Is enforcement cover required, and things like that. So I think that kind of finishes from my side. So I'm happy to hand back over.
Thank you, Alexandra, Vincenzo. As expected, your presentation has been very rich, very interesting. And I think you have prepared ideally the background for Fabrizio's presentation. Fabrizio will be focusing on the IP litigation. I have a short bio of Fabrizio. Actually, I must have, Fabrizio does not need a lot of presentation because he's well known as one of the most experienced lawyers in IP law in Italy and abroad as well. But nonetheless, I will provide a few words. Fabrizio has been practicing intellectual property law since 1988. He founded in 1996 his IP law firm, counting now 14 partners, 40 associates, with offices operating in Italy, France, and Spain. He's regularly involved in large cases, and he will be providing shortly an overview of the litigation explosion, because it's a fact that IP litigation is exploding, and it's a trend that will not stop. It's easy to imagine that it will not stop. So Fabrizio, the floor is yours. I think we have enough time to go through your presentations without being too obsessed by the time limits. So take as much time as you wish to conclude your presentation.
Thank you very much. I think it is always dangerous to say that you have plenty of time, because it is well known that lawyers can speak on and on and on for ages until everyone in the audience is probably bored to death. But so I will still try to be concise, because I think that concision is very important to make a presentation effective. The title of this presentation is the IP litigation explosion. As you said, the increase in the number of intellectual property litigation has increased over time. Is a fact. But I would try to examine the reasons or the causes of this explosion, and in particular how this may have an impact on the litigation in Italy, even though, as you certainly understand, litigation, intellectual property litigation, is not restricted to Italy, even though you might be an Italian company. But there are reasons that, significant reasons, that lead me to believe that the litigation explosion will also increase, and substantially, within the Italian territory, and therefore affect also those companies whose business is mostly concentrated in Italy. I will not reveal the name of the culprit right now, in line with the best tradition of detective stories, but you will find out in a short time why there's going to be this explosion. But first of all, since I was asked to do that, let me just briefly recap what are the intellectual property rights. This has been covered by you, Vincenzo, but I will try to give it not just a list, but also a brief explanation of what they are and what they tend to protect, because sometimes I notice that there is a bit of confusion about these rights. So the first thing that we have to understand about intellectual property rights is their nature. Intellectual property rights are territorial in nature, have a territorial nature, which means that they are limited to a certain jurisdiction or to a certain number of jurisdictions. There could be intellectual property rights that are purely domestic, intellectual property rights that are multinational, but there is no such a thing as a word patent or a word design and so on. Even by virtue of international convention, although copyright is recognized when created in one territory, in all the territories that are part of the Berne Convention, it still is a territorial right. That is, it is governed in each of these countries by the specific laws that apply in that jurisdiction. So what are the IP rights? Well, the most frequently spoken of are probably the patents. And the purpose of the patent is to protect innovation, to protect technical innovation. That is, to protect those innovative solution to a technical problem. They must have a technical effect, they must be new, they must be involve an inventive step to be validly granted. Trade and service marks protect the goodwill attached to those signs and protect the goodwill of a company. Designs, registered designs, they protect the shape of products. Therefore, they do not protect a technical solution, but they protect a new original shape that is given to an existing product. Copyright protects creativity of authors or of the company employing said authors. Trade secret protects, in general, non-patentable inventions, even though they can be used to protect also patentable invention in the event that this invention can be maintained and kept confidential for a time that is presumably longer than the duration of a patent. There could be other IP rights that are less known and also less frequently discussed. They could be extremely narrow or niche patent rights, but they're still important, from databases to breeders' rights. There's rights that are given to those that develop new vegetable varieties, rights of publicity belonging to those that have a reputation, whose image is capable of attracting goodwill, and so on. So the range of IP rights is extremely wide. They protect different aspects of a company's, and they also of a company, of a life of a company, and they have, as I said, territorial nature and not necessarily they're not necessarily recognized in the same way throughout the world. The next question is then, why are intellectual property rights litigated? First of all, and important to stress that this point, it's not that if you don't own any IP rights, you will not be involved in a patent litigation or in a trademark litigation. Actually, if a company does not own any IP rights, does not have an IP portfolio, is more likely to be attacked by competitors because it's not in a position to retaliate. So if you think that by not owning intellectual property rights, you'll be safe from intellectual property litigation, it's not just wrong, you're grossly wrong. And you actually are more likely to be involved in intellectual property litigation. The most common type of litigation in intellectual property are either infringement, which is a claim that is brought following an alleged violation of the exclusivity granted by intellectual property right. Theft, which is the unlawful appropriation of trade secret, and that can be pursued both in civil and criminal courts. Validity, when the validity of a property right is attacked because, again, allegedly the legal requirements for the validity of that intellectual property rights are not satisfied. And finally, litigation about entitlement, that is, conflicting claims to ownership of a specific intellectual property rights. And this may happen when contract relating to research and development, or contract relating to the commissioning of developing a new process, product, writing software, are not clear as to who will own the results of this effort. Where do you litigate intellectual property? Well, the truth is, in a lot of different places. And the reason is that even though IP rights are territorially limited, as I said before, the infringement of IP rights, or one type of IP rights, may result in international IP litigation. If you make a product that is allegedly infringing one specific patent, if that patent covers more than one country, you may end up being sued in each of these jurisdictions. This means that the violation of one single invention may result in 2, 3, 4, 5 different separate lawsuits. And where that may happen, obviously, is everywhere where you carry on your business. Or it can be where you'd like to do business, because, for example, if you want to enter a specific market and you realize that there are obstacles created by the existence of certain intellectual property rights in that country, then you may need to, the first thing, to get rid of those rights and see and explore manners to either circumvent those rights, to either not infringe those rights, or get rid of them by invalidating them. But that's not enough, because it can also be, as has been stated before, where your clients do business. If you sell components to your clients and they use that components in other jurisdictions, and in those other jurisdictions that components may end up infringing third parties' rights, then your clients can serve your third party notice seeking an indemnification from you in the event of a successful action for infringement brought by the patent owner or by the intellectual property owner. So as a consequence, as soon as you start doing business, you are exposed to the risk of a litigation intellectual property area, not only in the country of origin, but also in the country where you trade, or in the country where your products may end up, even when you don't even know that those products can be actually used and sold in a certain jurisdictions. Because remember, if you are not willing to actually sell in that jurisdiction, that may be a defense for a claim of damages, but not from a claim for infringement that may still result in an order prohibiting you from supplying that components in that jurisdiction. So let's move on to what is the main purpose of my presentation. What are the causes of this explosion in intellectual property litigation? There are many concurring factors. Some of the factors actually apply and will apply in the very short next future, specifically to Italy. As a first factor is there's an increase in the number of IP rights. Companies are filing more and more patents, are trying to secure more and more trademark rights, and they are certainly not reluctant from investing their money to register the designs of their new products. And there are companies that put on the market 10, 20, 30, hundreds of new products every year. And while in the past they may either not protect their shapes or protect only the shapes of those that they thought were the most potentially successful products, the decrease in the cost of obtaining protection for intellectual property rights has made possible for the same companies, by investing the same amount of money, to secure broader, more extensive rights for all their products in more jurisdictions. The increase is also dictated by the fact there is a greater awareness of the competitive advantage given by intellectual property rights. So companies know that if they register a design, they can exclude competitors from copying it, and if they can do it cheaply, they will do it. The technology advanced in several Asian countries, which meant that the typical players in the world of IP, Western Europe, Japan, and North America, are no longer the only players on the market. You have China, you have Korea, you have Taiwan, you have countries that are filing thousands of patent, design, and trademark applications every year. So the number has literally exploded because of the increased number of players on the market. Also, importantly, if you have an intellectual property portfolio, what happened very frequently is that companies didn't use the whole portfolio. They didn't use all the invention for which they obtained patent protection. They may not be using all the trademarks and design and so on. But and for a long time, when companies were not using those rights, what they did was, well, we don't want to spend more money keeping them alive. We just drop them and save money. But then they realized that the amount of money they were saving by doing so was minimal compared to the value that they could extract from competitors by actually enforcing those rights. So patents in particular, but that applies also to some other rights like designs and to a lesser extent trademarks, are no longer abandoned, but they're used as a tool to generate revenues at the expenses of competitors. Also, there's been a change in the approach in a lot of courts, surprisingly enough, even though slowly, also in our jurisdiction, in awarding damages for the violation of intellectual property rights. They are not only more generously granted, but more frequently granted as well. Another reason is, that was mentioned before, the rise in the number of non-practicing entities. Non-practicing entities are companies that own intellectual property portfolios, and their business is that of using that patent portfolio to generate revenue. So they don't have any, they don't make any product, they don't provide any service, they just sue alleged infringer to grant licenses. What has happened here is that companies that have, dormant IP assets will sell those IP assets to non-practicing entities for that purpose. And the reason is that sometimes companies don't want to enforce their IP rights because they're afraid that their competitors will then retaliate by counterattacking, enforcing their own IP rights. But they can make money by selling their IP assets to non-practicing entities who are not exposed to the risk of retaliation because they don't make any product. So they can freely enforce their rights without any risk. Other causes of explosion of a lower impact, but still there, is that, as you certainly are aware, if you read in the press and the newspapers, that there's constant investigations by antitrust authorities into the practices of tech giants. And that had as a consequence that the smaller tech companies have felt emboldened to pursue claims, and they think there's a more friendly environment for them to pursue claims against big technological companies. This is not a development that affects Italy, as we don't have those type of companies, but it's certainly noticeable at world level. Also, China, who has been for a long time a country known for the number of infringing IP rights, now become a country, one of the countries filing the largest number of patents. And the Chinese government is creating a more friendly IP environment now that China and Chinese companies have developed their own big, strong IP portfolios. By making it easier to enforce IP rights by granting higher damages, the Chinese government is actually making the life of their local national companies easier in enforcing their rights against other Chinese companies, but also against foreigners. But let's move to what may happen in Italy. Now, there are at least two developments that's going to take place within the next 2 years, and that will, I think, radically affect the litigation and the scenario in Italy. First of all, the unitary patent. What is going to be the unitary patent? A unitary patent will be a single patent covering the almost all countries in the European Union, except basically, as of today, Poland and Spain. Why is this as a change? Why should we see this as a potential change? Well, the reason is that, as we will see in the numbers that I will show you in a minute, while today, for a lot of non-Italian companies that want to protect their inventions in Italy, they have to specifically either apply for an Italian patent and pay the cost for it, or once they have obtained a European patent, to validate the patent in Italy, again incurring a cost. With a unitary patent, all the patents filed through this system will be automatically and without any increase of cost extended to Italy. This means that the number of patents that will be potentially enforceable, that is available for use in litigation in Italy, is going to increase enormously in the next 2 years. And we'll see how enormously this is going to be. This means, of course, that's going to be a much higher risk of litigation because there are more rights. And if there are more rights, statistically, there are more chances that these rights be infringed. But there's another development that can make the litigation world for Italian companies less friendly and riskier, because to a certain extent, the fact that our judiciary is one of the least efficient in the European Union, actually probably the least efficient in the European Union, has somehow protected infringers. So one may say, well, the number, if there's an increase in the number of patents in Italy, this will lead to an increase in the litigation, but Italian courts can hardly cope with the present number of cases. So what will going to happen is that we'll have more litigation, but this will move at an even slower pace, so that by the time we'll have a judgment, there won't be an interest anymore in the dispute. Well, this is not necessarily true, or would not be necessarily true in 2 years from now, because in addition to unitary patent, also the Unified Patent Court will enter into force. Now, Unified Patent Court is going to be a specific court operating at a European level that will have exclusive jurisdiction for any dispute concerning unitary patent, as well as, under certain conditions, pre-existing European patents. Now, what does this mean? It means that Italian companies will not be necessarily be sued only in Italy. Now, of course, an Italian company, if it's infringing a patent in Germany, is sued in Germany, but the decision of the German court will not stop the Italian company from continuing to make the same product in Italy and in any other country where, you know, either there's no patent or the German decision is not able to reach him. But the situation with Unified Patent Court will change dramatically. The first thing is that if you're infringing a patent, a unitary patent, whether it's in Italy or in another country, you may end up being sued in the Unified Patent Court, but not necessarily in the by the Italian Unified Patent Court. Depending on circumstances, you may end up being sued in a court in Germany or in France for acts of infringement that did not even occur there. And one should also remember that if a company is sued before the Unified Patent Court, the language of the proceedings may not be Italian, even if the decision may have an impact on the Italian market. So you may end up being sued in Germany, in German language, with a decision that will have effect in almost the entire territory of the European Union, including Italy. This will mean that there is a higher risk of liability and increased costs for Italian companies. And also, if you add to this scenario the fact that there will be thousands and thousands, tens of thousands or more patents valid in Italy, I think that risk should not be underestimated. Let me just show you this a little bit more in detail. I know you've seen these figures before, but I think it is important to understand. Now, these are the European patent applications filed by Italian companies in the past 10 years. There seems to be a big difference, but in fact, the numbers are quite stable. I mean, we go from 3,000, 3,900 to 4,500. So the Italian companies are filing in between 4,000 and 4,500 applications every year. When there will be unitary patents, it means that the Italian companies will, on average, own in Europe a portfolio of 4,500, let's say, patents every year. Patents last for 20 years, so you can easily make a calculation of how many patents more or less you can, the Italian companies will own at the European level. Remembering that not all patents are granted, that some patents are abandoned, so we'll be probably talking about 40 to 50,000 patents. Now, let's look at our Italy main competitors in one of the areas of technology where Italy is leading with this machine tool. It's Germany. Main competitors in Europe. Now, Germany is filing about, on average, 5 times the number of patents filed by Italy. Now, today, of these 25 on average, 1,000 German applications filed every year with the European Patent Office, about a fifth are validated in Italy, actually less than that. So we're talking about, let's say, 5,000 patents are extended to Italy. Once the unitary patents will be enforced, all 26,000 patents will be enforceable in Italy. That is, the number of patents owned by German applicants will increase 5 times almost overnight. This is a number of European patent applications filed by, all nationalities. So we're talking about 180,000 in 2019 and 2020. Of this 120,000, every year, no more than 40,000 are extended to Italy. In 2 years from now, because of the unitary patent, presumably all or almost all 180,000 patents will be extended to Italy. That is, even in their domestic market, Italian companies will have to face a almost 5 times increase in the number of patents owned by foreign entities that are enforceable in Italy. The risk of infringing one of these patents is therefore of infringing any patent is going to be therefore multiplied by 4.5. Now let's have a look at some data concerning damages award in Europe. Now I've provided a list of the top 10 recorded damages award only for patent infringement in Europe. The top is 25 million euros granted by the Tribunal de Grande Instance de Lyon in the textile areas. Then we got on 20 millions in Madrid. So you would expect huge awards in jurisdictions such as Germany or maybe United Kingdom. That's not necessarily the case. I mean, you can be sued for and be ordered to pay tens of millions of euros of damages also in France, and as you can see in Spain. Again, we have Paris, Barcelona, and then we have a fine in Netherlands, Paris again, Barcelona, Paris, and Barcelona. So Spain and France are actually risky jurisdictions, at least when it comes to recorded judgments that are publicly available, and therefore, you can obtain this data. But let's have a look at the number of patent cases in Europe. So that just to give you this is the number of patent cases filed in Europe over the past 5 years. In the period, 2015-2019, I couldn't get more accurate data for the recent past, but the reason is that the number of cases for 2020 and 21 is not yet fully available, and therefore I prefer to rely on more solid data. Apparently, the trend has been a slight increase in 2020 and 2021. So actually, as you can see, Italy is already a country, the second country for number of patent cases filed. Now, remember, I'm talking about patent cases, but we should make intellectual property also means in design cases, trademark cases, and so on. For your information, on average, per each patent case filed, there are 4 trademark cases filed. So the number of trademark cases filed is about 4 times the number of patent cases you see here. Talking about top recorded damages award, it is important to make a specific, to use those data with some precautions. In more than 30 years of experience as an intellectual property litigator, I can tell you that almost 9 out of 10 cases are settled out of court, and in probably 19 cases out of 10 damages are decided by the court. So settlement terms are obviously almost always confidential. Therefore, it is not possible to obtain reliable data on what are the damages paid in out-of-court settlement. Also, the matter is further complicated because in many cases, the out-of-court settlement is not a settlement just closing a case, but it is a license agreement. So the intellectual property owner, after obtaining a favorable judgment ascertaining the infringement, will grant a license to the alleged infringer, and therefore the amount paid by the alleged infringement is not recorded as damages, but as royalties. But this again can be substantial figures. Litigation costs in Europe, this was touched upon, but I think we should have a look at least what the average is in Europe. Now, the litigation cost in Europe is very different from continental Europe to the United Kingdom. In continental Europe, the cost of litigation can vary between 60,000 to 100,000 euros per party. That is, if you have 3-4 parties to litigation, each of them is going to spend more or less this amount of money. In the United Kingdom, the cost per party is far higher, is 1.5 million per party. And remember that until the Unified Patent Court comes into play, you can be sued in more jurisdictions. Now, it's difficult to make, as of today, an estimate of how much can a litigation before the Unified Patent Court cost, because no one has real experience about that. But based on my experience and based on on the current rules of procedure for the Unified Patent Court, my educated guess is that the range of costs can vary dramatically depending on the nature of the case and how much one of the parties is willing to spend. Because if one of the parties is willing to spend a lot of money by hiring independent expert, by submitting laboratory testing, by, in other words, generating evidence in support of its claim that is or can be organized in an expensive way, then the position of the other parties to counter that tactics will necessarily have to go through the same organization of litigation strategy, and therefore incur similar costs. In other words, the cost of litigating before the Unified Patent Court can be probably between 100,000 and 150,000 euros, but go up to figures that are not very distant, very dissimilar from those that we expect today in a UK patent case. Let's move to the scenario in the United States.
Sorry, Fabrizio. May I suggest that we shift to the final slide, because you have interesting conclusions, and I think we need to.
Yeah, let me just go through this. This is second final, and as I say, this is the United States. United States, you have every year between 5,000 and 6,000 patent cases, with awards in 2020 for $4.67 billion. So the figures in the United States are staggering, and one of the reasons that a lot of cases actually results in award in court. Often cases in the United States are settled after a first instance decision, and therefore a larger number of data are available. But let's move on to the conclusion, because I think at this point you understood where I'm going. And first of all, cost of intellectual property litigation can be very high. It continues to increase each year, and with the Unified Patent Court, we in Italy may expect a dramatic change in how we litigate and the cost we are accustomed to incur in patent litigation. How can you protect your company from this situation? Well, first of all, as I mentioned before, developing a proprietary IP portfolio may protect you to a certain extent because it provides you a tool, it provides you weapons to retaliate. And second, as mentioned before by other speakers, is obtain appropriate insurance coverage. Because, let me make this parallel, running around can get you arrested. You may get forced to medical treatment, or you may just ridicule yourself, but you'll survive. You won't die. In the world of intellectual property, if you get caught naked, well, this can carry a death penalty for your company. Thank you for your time and for your attention.
Thank you very much, Fabrizio. Very interesting. I must tell you, I learned a lot. It's Ellie's time now. We have the final presentation. Ellie is intellectual property underwriter at Tokyo Marine Kiln, and she will provide a presentation including a couple of interesting case stories. So please, the floor is yours.
Thank you, Claudio. Hi everyone, thank you very much for having me this morning. It's been two very interesting presentations so far, so I'm glad we're all gathered to talk about intellectual property risk, which is obviously an area that I feel strongly about as well. So I'm just going to do a very short presentation about intellectual property insurance from the perspective of an insurance carrier. So I'm not sure what part of the analogy we would have been in your naked story, Fabrizio. Maybe we're the clothes, hopefully, to help protect the clients. But in terms of our kind of appetite for sectors, I think consistent with what sort of Alexandra said, we have quite a broad appetite. So we see a huge variety of clients from lots of different sectors. I've just pulled this image from TMK's Our Focus website, which is the link I've provided below. And essentially what this kind of highlights is that we would look at pretty much everything. If it's a green tick, it probably means we have a client in this sector. A sort of orange tick probably means that we would look at it on a case-by-case basis. So a big variety, very broad appetite, and in general, pretty much any client can have IP exposure. As my fellow kind of presenters have touched on, you don't have to have your own intellectual property to be exposed. As Fabrizio said, you're actually more likely to get sued. So we really are open to considering most clients, and we also are happy to kind of craft specific policies to make sure that the exposure that each individual client is concerned about is covered. So as Alex said, if you're only concerned about patent trolls, then we can craft a policy just for patent trolls. If you're concerned about competitors and patent trolls, then we can do that as well. So happy to kind of really take your exposure and transfer it to us. Just to pull out, I suppose, a few specific areas where we've had maybe more success or are getting most of our inquiries from. Again, I think I'm going to probably align with what everyone else has been saying this morning. Firstly, we're seeing quite a lot of inquiries be driven by contractual exposures. So where our clients are either required to provide a contractual indemnity in respect of intellectual property to their customers or to people that they are supplying products to. That's been a really growing kind of driver for intellectual property cover. I think as more and more examples of where this contractual supply chain risk can be increasing, and also where it can go wrong, we're seeing more examples of that. We're therefore seeing more companies put those kind of indemnity clauses into their contracts and therefore seek to transfer that risk once they realise, you know, if you try and quantify the number of different indemnities you've given out it then tends to become something that exceeds expectations, and the clients don't want to retain themselves. Another area that I think we're seeing a lot of activity from is any client that has touch points in software and technology. And I think, as you've probably heard already today, that's largely driven by patent troll exposure. But what we are seeing is, as sectors become more tech friendly, so now, you know, a kettle used to just be a kettle. Now it's probably got an app where you can turn on your kettle from your phone and it tells you exactly the right temperature for your cup of tea or whatever. So there are lots of new sectors that now have touch points with software and technology. So patent trolls don't only have to target pure software companies now, they can target a range of clients who are probably operating in industries that previously weren't as connected as they are now. Another sector where we're seeing quite a lot of activity is manufacturing. I appreciate that's quite a broad sector, but in general it's linked probably to the sort of supply chain contractual exposure. And also in manufacturing, there's usually manufacturers deal with intellectual property rights from many different parties, whether they're integrating different products together into a final product, or, you know, using the designs given by someone to then manufacture the product. There can be quite a lot of exposure there, but potentially not as much recognition for the kind of complex IP arrangements that can be in place in that sector. And the final one just to touch on is life science and biotech. As Alexandra said earlier, pharmaceuticals and life science can be more exposed, more difficult, because the intellectual property litigation in that sector is very high. It's also a sector where individual IP rights can be extremely valuable. So an individual patent can generate billions for a company. So that's why we've seen in our experience those sort of companies tend to have a strong recognition of the value of their IP, the kind of value that it adds to their company, but also can see the downside potentially of that with the risks associated with intellectual property litigation or challenges to their IP rights. If we could just move to the next slide, please. So now on to the most important part of an insurance policy, the claims handling. Obviously, this is the part that everyone does and should care about most. The claims conditions in the TMK policy are well established and essentially follow the process of a claim from first notification to ultimate resolution of the matter. They're well tested and they do provide an element of certainty when everything else is probably going wrong. So in the event you have a claim, it's usually a stressful and pressured situation. It's probably taking up more resource than you would want it to. So the idea behind our claims conditions is that they're very clear, they're very specific, and therefore they don't add to the uncertainty of the situation. As an underwriter, I don't do the claims handling myself, and therefore I feel in a comfortable position to brag about our claims team, who really are kind of best in class. They win the Grace Touch survey pretty much every year. You can see on the slide, I think they've won since 2017. And they are one of the most experienced claims teams in the London market. So at TMK, we've been writing standalone intellectual property for over 10 years. So they really have dealt with a huge variety of matters, clients of all sizes, sectors, different types of IP. So they're very confident and experienced. And that sort of ties into the next point, which is about the proactive support for clients that TMK can provide through the insurance policy. So it can come in many different forms. For smaller clients, or say clients that haven't dealt with intellectual property matters before, the claims team can get more involved and provide much needed sort of expertise and experience. We have a very strong connection with lots of different law firms who we've worked with on previous matters, so we can put clients in contact with law firms. But having said that, we don't have a set panel. So it's our opinion, and one that's worked well for us previously, that there is so much variety in the intellectual property world and you can get sued in all kinds of different jurisdictions and over different rights and different sectors, that the panel would have to be pages and pages long. That we do let clients, we work with clients basically to select suitable representation, and we often find that clients are able to work with their existing law firm. You know, this existing law firm will know their IP the best, they'll know their strategy the best, they often know their products, so that's in everyone's best interest to get the matter resolved quickly and for the best outcome for the client. If we could just move to the next slide, please. What I'm going to talk about now is just go through a couple of case studies, because something that we found is when you talk about sort of intangible assets, sometimes it can be difficult to imagine the type of loss and how the policy would react in that situation. You know, everyone understands that if you have a fire in your house, how your property insurance will respond and how that process works. But with an intangible asset, such as an intellectual property right, it can be more difficult. So here are two case studies. They're obviously anonymized and fictionalized to a certain degree, but they do reflect true cases that TMK have handled or inquiries that we've seen. So the first one is a patent troll dispute. So this is with a non-practicing entity or a patent troll. And these types of claims are very different to competitor claims. So handling them, if you've never dealt with a patent troll before, can be quite difficult. In this specific example, it was an international operations company, and they offered some digital solutions to do with, say, logistics or supply chain management. They received a number of warning letters from a large patent troll. So this patent troll has sent them letters saying, we believe you infringe on these patents of ours, and if we think you need to pay us X, Y, Z damages, and they threatened to take legal action, i.e. take it to the courts if the letter was ignored. This triggered the TMK policy, and we were able to provide the insured with access to a law firm that is specifically kind of set up to deal with patent troll issues. So they have a huge amount of experience dealing with patent troll claims specifically. And this law firm also worked with the insured's existing IP legal counsel, who were familiar with their intellectual property and product range, etc. The ultimate outcome is that it didn't go to court, but we were able to negotiate and reimburse the insured for all of their attorney fees and ultimately a six-figure settlement amount in addition to that. So a good example of kind of where a claim that a company might not have been able to handle as well on their own. You know, it's a very specific type of a litigation that we helped them with, and obviously they were reimbursed for indemnified for the costs associated with the claim. The second case study that I'll go through quickly is to do with a patent challenge. So this was a European life science company that has patents for a medical device. They don't make much revenue yet, but they do have significant investment. And I think it's safe to say a lot of that investment was provided on the basis of these really valuable patents that the company holds. Unfortunately, a competitor organisation launched a patent challenge. They said that they believed that patent was invalid, and they actually targeted one of the kind of foundational patents in the portfolio. So this was a patent that had lots of international family members, and they'd achieved sort of worldwide protection by this patent, but they challenged the US patent in the US PTAB, which is the court system there for this type of proceeding. This is covered under the intellectual property rights protection coverage under the TMK IP policy. And we worked with the client's choice of counsel. Essentially, we had to meet quite a few tight deadlines that had been set by the PTAB. And we worked with their normal law firm, and actually our claims team were able to negotiate lower rates just for the purposes of working with them on this claim. Ultimately, the PTAB ruled in the insured's favour, which is obviously great news for everyone. The legal costs, because it was a very technical and specific type of technology, just for this, what is known as an administrative proceeding, still cost in excess of €1 million. So we were able to indemnify the client for all of the legal fees and all of the costs of the expert consultants. And just as a sort of added bonus, I suppose, from the client's perspective, the law firm now still works with them, but does still work at the lower rates that we negotiated from the claim side. So these are just two case studies. We've obviously got, these just cover off two kind of specific examples, but hopefully they've kind of helped bring it into context a little bit. And yeah, if anyone has any questions, that's the end of my presentation. So happy to take any questions or comments. Thank you.
Thank you, Ellie. We are absolutely on time. We have just a few minutes. I think we have a couple of questions. And in fact, I would have a lot of questions, to be honest, because there is a lot in your presentations, and each of them would deserve more time. Perhaps we have been receiving inputs for another session, another webinar in the future. One question is for Fabrizio. You mentioned earlier the costs. Unsurprisingly, costs in UK, because they have a different legal system, are much higher than costs in other European countries. But do these costs include the expert costs? The figures you gave us, 60 from 200,000, do they include the expert costs?
They include the expert costs in each jurisdiction. The difference that is the type of expert and the number of experts. For example, in Germany, the court does not usually appoint an expert, and expert submissions are considered relevant, but in most cases, except the most complicated telecom, pharmaceutical cases, you may have one expert per party. Same in Italy. In France, the experts submitting declarations are very much aligned to the situation in Italy and Germany. In the UK, it's different, but the main difference also that in all these continental jurisdictions, experts will make their own written submissions, and that's the end of the story. In the UK, if you go to trials, not all experts, but some of them will be heard in court, will be examined, cross-examined. You need to prepare the expert. There's a lot of work that has to be done that goes well beyond what is usually done in continental Europe, leaving aside all the discovery phase. And in the United States, that is multiplied. I mean, the number of experts, the duration of examination, cross-examination, and the amount of documents subject to discovery is a multiple, is a number of times what happens in the UK. So that explains the difference in cost.
And you have just triggered my curiosity. You have you practice in France as well. You have an office in France. I'm
Yes,
very frequently involved for product liability cases in France. And in France, the pre-trial expert evidence, what we call in Italy l'accertamento tecnico preventivo, is the rule. It takes a lot of time, and it could be expensive. Is it the case in France for IP litigation cases as well?
Not really. The cost of experts and the cost of obtaining evidence in France is very similar to Italy. The two legal proceedings are different. They are organized differently.
Yes,
the way in which they move is very different. But by the end of the day, I apologize. By the end of the day, costs are not dissimilar.
Okay.
So for similar cases, will end up costing roughly the same.
Okay. As we have seen, legal costs could be an issue, and insurance protection and coverage regards these costs. It's an important element. As a final comment, I'm grateful for your presentations because I think it has been very interesting for me and for the audience to see the vast array of instruments you can get, you can find in the insurance market for the protection of the IP rights and all the implications related to litigation. We knew, but we've been confirmed that litigation is here to stay and will probably soar over the years. So I think it has been very, very interesting. It has been very interesting for me, and I'm sure it has been from the audience. I've been checking the chat. There have been a lot of messages, thankful messages from the audience. So, and we are on time. So I think we have the perfect combination.
Exactly. Thank you very much, Claudio, and thank you to our attendees, but of course to our faculties. Thank you, Alexandra, Ellie, Fabrizio, Claudio, and also to Vincenzo. He is having some technical problems, so he can be here with us. But thank you again also to Eon, and see you to the next webinar. Have a nice day, everybody.
Bye. See you soon.
Thanks.
Bye. Thank you.
Bye.
Thank you. Bye-bye. Bye-bye.
Thank you. Bye.